Welcome to Season 3 of Sidebar with Judge Dan Winslow. I am Judge Dan Winslow, formerly of the Massachusetts Trial Court, now with the New England Legal Foundation in Boston. Sidebar is a 45-minute long podcast about interesting topics at the intersection of business and law. Today's show is ripped from the headlines as well as the headnotes of judicial decisions. Did you know that the federal government can take property from American citizens without any notice to those citizens or an opportunity to oppose the government action? Well, that's the position of the Department of Justice here in Massachusetts when they seized $1 million of John Wilson's property without any actual notice to him after he was exonerated by the Court of Appeals in Massachusetts. Thankfully, a federal judge disagreed with the Department of Justice's position in a case where the New England Legal Foundation filed an amicus brief, a friend of the court brief, in support of John Wilson's case. We're here to talk about that issue and to provide the context from John's point of view about the Varsity Blues case, a case where Hollywood A-listers were convicted of bribing colleges to get their non-athletic kids into colleges as student athletes by fake credentials and fake poses and the like. So first, our guests. John Wilson, to the far end of my right here, has helped businesses achieve their full potential across 20 industries and 95 countries. He's a proven track record of turnarounds and major growth successes through both C-suite and consulting roles. As CFO and EVP of strategy, he helped Staples become the fastest company in history to make the Fortune 500, 8 years from concept. As Chief Operating Officer of Gap, he helped the company double its revenues and more than quadruple its profits and market value over 5 years to become the first specialty retailer to achieve a market cap of $50 billion, all from a kid who grew up in the projects. John, thanks for joining us. We also have here to John's immediate left, attorney Karen Pickett from Boston. Karen is a cum laude graduate of Holy Cross in Worcester, earned her law degree at Northeastern University School of Law, and from 2014 through 2020, Boston Magazine named Karen as one of the top 50 women lawyers in Massachusetts. She's won cases as a public defender, an appellate law clerk, a large law firm associate, as a partner at a litigation boutique, and now as the principal of her own shop doing white-collar defense as well as appellate work, and she served as counsel to the New England Legal Foundation and wrote our amicus brief in support of John's case. And last but not least, to my immediate right, Mike Kendall, a partner at White & Case. Mike's a Harvard-trained counsel known as a superlative trial lawyer as well as a tactician. He's received a Band 1 rating from the prestigious Chambers publication as well as many other professional recognitions. And Mike was lead counsel to John Wilson in the forfeiture case that we'll be discussing today. We're going to start this podcast with a video for the video audience, and then we'll have John recap for our audio audience about how we got here and what the case involved. So let's cue the tape.
About 98% of all cases the government brings ends up in conviction. Prosecutors know how to stoke the press to build their case.
Today's announcement from federal prosecutors was a shocker.
They write what sells newspapers or gets them viewers.
The story is a bombshell.
If you can put a bunch of wealthy and famous people in the court system, it gets great publicity. And that's how some prosecutors build their careers.
Massive college admission scandals.
Operation Varsity Blues.
Some of the parents are famous.
Cheating on standardized tests.
Presenting students as top athletes in sports they never even played.
We want to take you to good breaking news for a change.
The youngest ever to swim the treacherous waters from Alcatraz to San Francisco.
He did it, I'm so proud. I'm the happiest dad in the whole world.
Welcome Johnny Wilson to the show. Johnny.
On March 12, 2019, my version of the American dream came crashing down and turned into a nightmare.
This morning, 50 people arrested.
I was arrested for honest services fraud by 2 FBI agents getting off a plane in Houston. And I thought it was a case of mistaken identity.
When I got the phone call, I assumed they had arrested the wrong person, not my John Wilson.
I was then taken to a federal prison, stripped, hosed down, given a jumpsuit. The guards told me to watch my back because as an old white guy, the other prisoners would assume I was a pedophile. And I could be stabbed with a shiv.
John was the one person who lived in Massachusetts. So John becomes the anchor that pulls the other 50 parents into Massachusetts.
The Boston prosecutors knew there would be media attention for this high-profile case. They wanted some of that for their own careers. 180 years of potential prison time, all to try to pressure me to plead guilty.
Perhaps the most frightening part of this story is the fact that the government had overwhelming evidence from day one that I was innocent the entire time. Their hardball tactics were so extreme that I would be shocked and wouldn't believe them myself if I hadn't experienced them personally.
Because if he went to trial, he was the best person to say the government doesn't have a case.
32 parents have pleaded guilty in
Singer pled guilty today.
We know he pled guilty. That's dangerous for everyone else involved.
What they didn't count on was me fighting back. And there was no way in hell I would ever confess to crimes I didn't commit.
The scale of this scam, just astonishing.
Once you're accused, 95% of the people assume you're guilty.
Rich people cheat and their kids are fucking stupid.
I want to correct the record for my children. I want the world to know that my children were innocent, they were highly qualified on their own merits, and I will spend every last breath defending them.
The first parents to face trial in the Varsity Blues college admissions scam.
I remember walking in the first day into the courtroom, and your whole family's future is on the line. I'd have to leave and cry in the bathroom, knowing they are tearing up our life.
I could have taken the easy path and pleaded guilty at any time, but my family and I drew a line in the sand. I knew that fighting for truth, we could all hold our heads high.
This case was the best example of prosecutors thinking from the beginning, how do we muscle these defendants into pleading guilty so nobody will ever look at what we did under the light of day?
It's been 5 years of emotional, physical, and financial hell. I want the world to hear my untold story, so something like this never happens to anyone else.
John Wilson, thank you for joining us here on Sidebar. We touched on it a bit, it's on the video, but how was it that you became aware that the federal government had a case against you?
I was completely shocked. I'd never been accused of a crime in my entire life. In fact, my whole life, I prided myself on following the rules. And so you can imagine when I was getting off an airplane, visiting a client in Houston, traveling from Europe, I was arrested by 2 FBI agents in the airport. And to my shock, I asked them, what is this all about? And they said, you're being charged with honest services fraud. And even more surprising, when I asked them what that was, they said, we don't know. We've never heard of it. That was their answer. I said, what? And they proceeded to bring me in to a federal detention center in Houston, literally stripped me down, hosed me down, 2 guards hosed me down, put me in a jumpsuit, and I was put in a cell block with 60 prisoners. Some of them said were hardened criminals waiting for appeals and other things. And they told me to watch my back because I was the only Caucasian person in that prison that was over 50. They said, they hate pedophiles, they're going to assume you're a pedophile here, and they're probably going to try to stab you. And I spent the next 2 days in that prison worried about being stabbed and threatening my life, and I still had no idea what I was even being charged with. They couldn't even tell what I was being charged. You can imagine, that's how it started. And it got much, much worse. And for me, education changed my life. Hard work and education have been the hallmarks of my life since my early childhood. I grew up with a single mom in the projects of Hartford. I picked tobacco for 4 years from the ages of 12 to 16 to help my family make ends meet. I did not have a silver spoon. Education was the key. It allowed me to escape those projects. And I was very proud of working hard and studying hard, and I instilled those same values, my wife and I, in our children. We never cheated on any test. So unlike all the other people that confessed to crimes in Varsity Blues, we were very different. My children got perfect scores and near perfect scores in their ACTs. They studied on their own. My children were winning math competitions throughout Europe. I was working in Europe for a job. My son was a national caliber athlete who was being recruited by the U.S. Olympic team, who actually played on Stanford club team for 6 years and played in national junior Olympic tournaments. He joined the USC team.
I was going to ask you on the video, it said Johnny Wilson. So that was your son at age, was it age 9? He swam from Alcatraz in San Francisco, was the youngest ever to make the swim?
Yes, at age 9. He's been a stellar athlete since he was 6. And at age 9, he had a world record that got him on the Oprah show and got a letter from the President of the United States. And he continued to go on to achieve national and international competitions in swimming and water polo. And his high school coach was involved in being recruited at USC. We went to USC and he joined the team. at USC. So unlike all the other parents, my children were qualified on their own. They worked hard. They studied hard to get perfect scores and near perfect scores. My son spent thousands of hours training in swimming and water polo and joined the USC team. And in fact, his actual swim times proved he was one of the fastest players on the national championship team. And in water polo, speed is the most important single variable that distinguishes players. And all of my donations were verified. I was recommended to Singer by Goldman Sachs.
And Singer being Rick Singer, who was the sort of the mastermind of all of this?
Yes, Rick Singer was the mastermind who had more than 1,700 clients. Many of them were very honest, hardworking clients like I was. It included Steve Jobs, it included John Doerr, Joe Montana, famous people. And Goldman Sachs recommended him to me and said he has this client list that's spectacular. So I trusted him. And he did real legitimate work for me. He did real legitimate tutoring for my children. He did real charity work. I drove my son to Sacramento from San Francisco on weekends to help tutor inner city children. I grew up in the inner city. I wanted that for my children. I wanted that exposure. So he did that. And so he did real work for us. And then when I lived in Europe and moved to Europe, he helped my son with his profile and his resume for his college applications. My son stayed back to finish his senior year in high school. And again, all of our money went to USC. We verified with USC, with the development officer as part of the athletic program, and with the coach, that donating to USC through Rick Singer's organization was fine. They said absolutely. They had experience with that multiple times. And I got a receipt from USC for my donation. So I was totally shocked being arrested. My kids didn't cheat. They were highly qualified. USC said if you make a donation, it'll help give you a tiebreaker boost in the admissions process. I said, fine. So we made a donation.
And I just wait you, Mike.
If I could jump in. One of the things that was most interesting about John's case is the role of Singer. He clearly was the entrepreneur that was responsible for all of these events. He had done it for years, and he was the government's cooperator, making wiretap phone conversations, being their star informant. They wouldn't call him at trial. Everybody was shocked. Why is Rick Singer not testifying at trial when he's the architect of everything the government is putting on trial? Because from the first day he was arrested, it's right in the FBI 302 reports, he said, John Wilson's different. His son's a legitimate athlete. He never thought he was bribing anybody. The money went as a legitimate gift to USC. John Wilson is different. And the reason that the government ignored what he said and kept him out of the trial was because they needed somebody from Massachusetts to justify bringing in 49 people from Texas, California, Nevada, Illinois. The case had no connection to Massachusetts and no justification under the venue rules for being brought in Massachusetts unless they could say they had a Massachusetts conspirator participating from Massachusetts. So that's why John became the invented defendant for the case, and they kept Singer out of the case because it was the only way to justify getting it in Boston so that the Boston prosecutors could get the publicity for themselves.
So just for folks that may not be familiar with the Varsity Blues case, let's just set the scene because there's a contrast. There's those other 49 people, those other 49 defendants. So let's talk about those folks. What were the allegations as to those folks by contrast to what was alleged as to John and his family?
There was a range of behaviors that people were involved in, some more serious than others. John was unique in that he was the only parent in the case whose son actually was on a Division I team and had been a star high school athlete. Also, it was uncontested that his kids had superb academics and achieved them honestly, and the tapes were endlessly. John was a bit of a taskmaster. The kids had to work, the kids had to practice. He was on top of them, making sure that the kids did it the old-fashioned way.
So by contrast, the other parents had their kids posing as athletes, phony records. Is that the allegation?
Different people did different things. Yep. Some people paid to have cheating on the SATs by having one of the people proctoring the exams actually correct the answers and get phony results for the kids. That was some, not all. Some people paid actual bribes to coaches or school employees, which clearly is a significant issue. Other people made donations and were told that it would be run through the athletic department. What was hidden by the government, but we were able to unravel and show in large part because of very strong rulings by the federal magistrate was that USC had a practice of selling admission slots to raise money as part of their $6 billion fundraising campaign. We had 150 examples of people who bought their way in through the admissions office and the fundraising through the athletic department. To say that some of these parents, not John, but some of these other parents, they were no different than these other 150 who had non-athletes that USC willingly admitted in return for donation.
So if John's case had been dropped, let's say that this information was known to the federal government, was known to the Department of Justice, that in fact John's son was in fact a world-class athlete, that his daughters in fact were scholars and scholar athletes. If it was a never mind, a do-over, let's just drop the Wilson family out of this case, what would have happened to the case?
You know, the prosecutions are organized by the district, which is the entire state of Massachusetts. They can only bring in Massachusetts cases that have venue in Massachusetts. If they didn't have John as part of the case, that group of prosecutors could not have brought the case and gotten all the publicity. And to be honest, I don't know that offices in California or other places would be so enamored in such a hodgepodge of behavior with, you know, maybe a few people that did things seriously wrong and a bunch of other people that may have shown some bad judgment. But we're not bribing people and we're not cheating on SATs.
So I want to ask you, so the case went to trial. It was not dropped. And the government gets to paint a picture of what they want to allege against any accused defendant. And in this case, there was evidence that was admitted, but there was also evidence that was excluded. I think that was also, a key factor in what the outcome was, at least of the trial. The point of a trial is to have a fair trial, and let the chips fall where they may. John, what were the things that were excluded from your trial that you think that the jury should have known?
It was one of the most shocking parts of this whole experience for me. I had never had any experience at all with the criminal justice system. And I thought that one of the things that would happen is that they would be lenient, the prosecuting judges, in letting a defense person whose life is at risk, whose liberty is at risk, share their evidence. But my evidence and my other motions were blocked 98% of the time. Literally 660 motions were blocked. And that included, for example, my daughter's perfect ACT scores. They were not allowed into a trial about college admissions. How could my daughter's certified ACT scores, a perfect score and a 99 percentile score, not be allowed? It was shocking. Another thing, my son's world record in Oprah and his swim times, his verified swim times with USA Swimming, that proved he's one of the fastest players on the USC team, not allowed into the trial. Even by his water polo coach, who testified and said he recommended my son to the USC team. My own will and my own emails were not allowed at the trial, nor were the 100 examples that Mike mentioned earlier about USC giving regular tiebreaker boosts to donor families in the admissions process. None of that was allowed into the trial. So over and over and over again, they just disallowed all of my evidence. It was so shocking that I just couldn't believe it. I was flabbergasted. And in fact, one of the lawyers who's a friend of mine who was having a cocktail party for one of the anniversary celebrations at a third-party firm where one of the prosecutors went to after this case. He was talking about the case, unbeknownst to him that this was a friend of mine, and he said that even they were shocked at how supportive the judge was of their rulings, that the judge was just instinctively and reflexively ruling in their favor, so much so that they kept going for more and more and more, and kept making more outrageous demands on evidence. And when the prosecutor says that he was shocked, then I was flabbergasted as well.
So then, of course, the Rick Singer testimony was excluded because Singer himself didn't testify and wasn't able to be asked about the statement of the 302 saying John Wilson's different. So that was the picture that was painted, and as a consequence of that case, you were convicted.
Yes, because I don't blame the jury. I think the jury, based on the evidence they had, made the right choice because all of my exculpatory evidence was excluded. On the flip side, they brought in all this other evidence. Other parents had nothing to do with this. People getting on the stand and saying, we all knew Singer was corrupt, we're all bribing, we're all cheating. I didn't know that person from a hole in the wall. And so you have the audience hearing, or the jury hearing again and again, we're bribing coaches on the calls, right? And then the FBI scripted call for me. I'd never say a bribe. Singer says, are you okay if we give a check to the coach? I say, fine. I always gave checks to the coach. It was a check made out to the USC Athletic Development Fund, the Trojan Development Fund. It wasn't a check made out to the coach, but when you're the jury and you hear 30 other parents saying, we're going to bribe, we're going to bribe, we're going to bribe, and then they play my call and he says, you're okay if we give a check to the coach, it sounds like a bribe. When it wasn't. It was a check made out to the USC Athletic Development Foundation. And so that way of misleading was deliberate, but also highly effective.
Right, and so you took an appeal to the First Circuit Court of Appeals, and Mike, catch us up. What happened there?
We had a fabulous panel, 3 great, very attentive judges who really bore down on the evidence. We got an exceptionally long opinion, about 150 pages, and they found multiple ways that the trial was unfair, that our evidence was not treated properly, but the most important thing that they focused on, which was probably to them the most important legal issue, was the idea of putting John in with everybody else and saying that all the parents were part of a conspiracy together, that the bad acts and knowledge of these other parents should besmirch John, and that was the lead issue on the appeal. And in some ways, it was such an obvious issue that the government should have known not to have ever tried that strategy. On the other hand, that was the only way they were going to get a conviction against John. And so, the appellate court just did a great job in that area.
So in the federal government, if somebody's convicted of a crime and there are proceeds, monies involved in that crime, whether it's a drug crime or other kinds of crime, fraud, white-collar crime, the federal government can move to seize, a forfeiture of the money. So in this case, there was a $1 million contribution that was made through this fellow Singer to the schools, and there was a forfeiture claim against you, John, when you were convicted, and that was pending at the time your conviction was reversed by the First Circuit. So what happened with the claim against Wilson directly? What did the federal government say to Wilson about his $1 million?
What they said was, we're sore losers and we're going to spite you any way we can. And that's what happened. They had brought a forfeiture count in the criminal case that was reversed by the First Circuit. And the First Circuit said, you want to retry it? Go ahead. And they didn't dare retry it. They quickly dismissed it and walked away from it because they knew they could never prevail in a trial that had to follow the rules as reinforced by the First Circuit. So we just assumed we were going to get the $1 million back to John. And we just sent an email, and they wouldn't respond. And, you have to be polite and respectful when you're emailing with the government. So I'm writing all these sort of polite emails. Could you let us know? What do we need to do? Do we need to give more information? And after about 3 weeks, it became clear they were not going to send back the money, so we had to file a motion. And they played cat and mouse for about 2-3 months till they finally said, you know what? We never intended to forfeit the money in the case that had John's name on it, that had specific claims to forfeit the $1 million clearly laid out. In Singer's case, which had nothing to do with John, where John's name was never mentioned, that's where we forfeited the $1 million. And you should have figured out we were going to do that, even though we said we were doing it in John's case. So we had to go through motion practice. It took several months. It took a substantial amount of time. And to be honest, everybody in the legal community that follows these things was laughing at the government's position, because the most fundamental issue in forfeiture law is due process, that you have to give the person who's aggrieved a chance to contest a forfeiture. And the fact that they could do some sort of like magician switch, oh, you know what, we're not forfeiting it in your case, we're forfeiting it in another case we never mentioned to you. It's just a lack of notice. And that is so fundamental to every aspect of our legal system that the government has to give people adequate notice so they can come to court to vindicate their rights.
So you filed a motion before a federal judge in Boston to have the judge order the money be returned.
Correct.
And that's where we got involved. The New England Legal Foundation got involved, and we engaged attorney Karen Pickett, who's there in the center, and a very accomplished appellate lawyer. Karen, thank you for your great work on that brief.
Oh, thanks.
Tell us from your point of view. You jumped into the case and you wanted to make a couple of points. What were the key points you wanted to share with the court?
So one thing that might not be clear is that the other guy, Singer, had a bank account, and that bank account had contained John's contribution of $1 million. Is that correct? And from the beginning, Mr. Singer started cooperating with the government. And while he was cooperating with the government, he solicited this donation from Mr. Wilson at the behest of the government. Why? Because he wanted to curry favor with the government. And that should be sort of shocking to everybody that, the government is sort of entrapping this guy who had, was acting legitimately. And I don't know the circumstances of, how the prosecutors felt or whatever, but as Mike Kendall said, it seems like, when they got slammed at the First Circuit, they were like, well, at least we can, keep this $1 million and prove, we got something right. And it was a very complicated, and I wasn't involved in all the facts and the trial and all that stuff. But our role at New England Legal Foundation was really just to say, this guy never got direct notice that they were taking his $1 million from another guy, John Singer. And the hallmark of Fifth Amendment due process is that and what we argued is that under the forfeiture statute, under the criminal rules, first of all, he had not been convicted, so he couldn't have been subject to criminal forfeiture. And second of all, as a third party, he couldn't have had his $1 million sort of scooped by the government without them providing direct notice to him. We're going to take this $1 million that you gave to Singer. And my brief was pretty short, like 9 or 10 pages, and I was just sort of hammering home those points. And the judge probably didn't go as far as we wanted, but she went far enough to say that John was right, that he should get his $1 million back. She sort of fudged all these different factors together. I don't blame her. It's kind of it was like a 42-page opinion. And as I didn't know, but John just said, the government didn't appeal it. So this is sort of the final decision. She may have been trying to bulletproof.
It's funny, Karen. The sort of the backstory is that in order to file an amicus brief, a friend of the court brief at the trial court level, the district court level, an amicus organization like New England Legal Foundation needs to ask permission. We have to file a motion called filing a motion to seek leave, to seek permission to file an amicus brief. And so you prepared that motion and you sent it to the federal government on the other side to say, hey, will you consent to our seeking permission to file an amicus brief? And did they agree with that?
Oh gosh, no, they.
And why did they not agree with it?
I think they just didn't want. I think that they didn't want somebody else supporting John's position and somebody who was sort of a neutral party. And I swear I've done a number of amicus briefs in my career. I've been practicing for 30 years. I have never had somebody not agree. I'm not saying that they had to agree with our position, but to say, no, we don't want you to file. Why wouldn't they want us to file? Why don't they want to know what maybe we can add to the case? It was shocking to me, frankly.
I think more interestingly than that, the federal government specifically said that they didn't have enough notice of our intention to file an amicus brief.
Yeah.
And I thought that was pretty hilarious because they didn't give John a notice to take $1 million of his property, but we hadn't given enough notice to file an amicus brief. It was a really interesting lack of
I think the judge allowed it so she must have thought it was pretty funny too, because that was a ridiculous argument. I forgot about
Mike, what I think was worth noting is an amicus brief is a sign of respect for the court. It's a lawyer saying, I've got no personal direct issue in this dispute, but this issue is important and we're bringing a perspective that is of a different party, but because the issue transcends this case and is important to many others. I mean, just think of the business community. If the government could be grabbing property without giving notice, people who have mortgages, people who have liens or whatever in property, it would just wreak havoc. And it was, again, a situation where the government didn't want the light of day on what its behavior was because it was too embarrassing. If I could just add one more fact, the concept which Karen brought out, and just to develop a little more, is Singer was working as an undercover operative. And so when he told John, oh, we can make a donation to a couple of other schools, give me $1 million and we'll give the money to the school, he's working as the government's agent, and he receives the money in a bank account that the FBI had opened with him to be used only for the undercover operation. When they were caught with this indefensible forfeiture claim, they said, because it was technically required, oh, that's Singer's money that's being forfeited. That's not the FBI's money that it receives in an undercover operation. Every informant that does a drug deal for the FBI or DEA doesn't get to keep the money or keep the drugs that are part of the undercover operation. It's only owned by the government. That's the most basic forfeiture law, that the money is the government's if it's a criminal activity. So for this case, they had a position they've never advocated anywhere else in the country, that Singer had a personal interest in owning and controlling the money that he received from an undercover operation. So really, what they're saying is Singer could have kept $1 million for himself, which of course is absurd.
You know,
two of the things that,
go ahead.
if I could, that are relevant in the context of this donation that I made, and it truly was a donation. First, in terms of backstory, I had, as I mentioned earlier, had my life severely and profoundly impacted by education. And I had been successful, fortunately, in my life, and wanted to give back. And so in my will, I was already committed, and Singer knew about this, to give millions of dollars to both Harvard and RPI, the two schools I went to. And so that was part of my will and part of the commitment. This was not allowed into the trial, but it was something that was there. Singer knew about that, and he convinced me to move up $1 million of that commitment earlier on. So that's the context. But secondly, we also did our due diligence. I checked with Goldman Sachs, who was my tax advisor, and I checked with my tax advisors and with the website that we verified that Singer's foundation was in good standing before we made this donation. I didn't just willy-nilly give Singer $1 million. It was in my will. I accelerated part of that commitment, and we verified with the IRS, and the IRS website said Singer's foundation. It went to his foundation, not to him personally. Singer's foundation was in good stead, and you could rely on the IRS certification to make your donations tax deductible. So we did our due diligence. I wasn't just sending money to somebody to bribe. It went to a certified foundation. So that's the context of this $1 million. That was very important.
I just want to add to something that Mike and Karen both said. The New England Legal Foundation didn't have any dog in this hunt, but we got involved not because of John Wilson, what happened to you and your family, Joe. We got involved because if this is the position, and a position that's allowed to prevail by the federal government, then no citizen would be safe from government overreach in a case like this, whether it's an individual, whether it's a company. It's fundamentally wrong, fundamentally contrary to our constitutional rights to have the federal government take property from a citizen without notice and an opportunity to oppose. And that's what happened to you, John. That's what happened to you, and I'm sorry that it took that long path to get your money back. But that's the end of the story, right? You've gotten your money back.
Yes, we did prevail. It took 3 different judges, but in the end we did prevail, and the government agreed, and they did give us our money back.
But you've gotten $1 million back, but you've also had to spend money in your own defense to clear your name and to stand up for your family. And what did that cost you?
It's been devastating. It's been 5 years of emotional and physical, reputational, and financial harm. I've lost all of my employment at the peak of my career for 5 years, and the legal costs to fight this through the appeal, including the millions of documents, was over $10 million. My entire life savings.
Now, under our system of justice, no, you don't get that money back, right? That's a lost cause.
You don't get it back, and you can't even deduct it from your taxes. So it's just every single penny of my savings, all of my 401ks, everything had been depleted entirely to fight this case. And we thought about this long and hard when we first spoke with Mike, and Mike warned us up front that fighting the federal government is not easy. Because they can, one, tilt the playing field to their advantage, and they win 98% of the time. He said it was going to be very expensive. It cost us even more with COVID and having to go to the appeals route than we ever thought. And he said it would be like being in the emergency room. It would be painful, emotionally and otherwise. And we were devastated with how viciously they attacked my children, even in the media, making false statements and smearing us through guilt by association. My poor daughters were 16 years old when this happened. And they were being smeared as being unqualified. Imagine having a perfect score that you worked for on the ACT and having the government say your kids are unqualified. Media were saying that things like they couldn't even get a job at McDonald's. So it was devastating not only financially, but even more so, I think, emotionally for the family and reputationally. And even after 5 years of getting everything overturned unanimously that was related to Varsity Blues, it's frustrating because where do we go now to get our reputations back? And that's just devastating.
Yeah, I always thought one of the reasons that the government was so spiteful and aggressive in this case is Because they knew if you go to trial and this gets exposed and it gets up to the appeals court, it cannot stand. And so every pressure imaginable was placed on John and one other father who both went to trial because they wanted to vindicate themselves and their families. And, you know, just think, dozens of people pled guilty, that even those that paid bribes or that did corrupt SATs, their cases would have been thrown out because the venue manipulation and the improper conspiracy charge was so illegal that any case would have been thrown out, which is one of the things that the First Circuit ruled.
You know, I often say that one of the greatest things that a child can do for a parent is to make the parent proud of the child. But I've got to think that the flip side is also true, John, for you and your wife to say your kids have got to be awfully proud of you having the spine and the Constitution, not just constitutional, but the Constitution, the backbone to stand up to fight for what was right at significant cost.
We did talk about this a lot as a family, and my wife and I really spent a lot of time agonizing over that choice, because it really was a choice from the moment we were arrested. Do you plead guilty and take the easy path, save millions of dollars, save years of anguish, and move on with your life? And we thought about that option long and hard, and we concluded that we couldn't do that. And we did get our children involved in that decision. And really there were three reasons for me that were most critical and profound. First, I couldn't live with myself publicly confessing to a crime I didn't commit. Secondly, confessing to that crime would basically confirm the false narrative that my children were unqualified. That's why I had to do it. I had to bribe because my children weren't qualified when that wasn't true. And I couldn't do that and support that false narrative. And then third, what the government did to me is just plain wrong. And it should never happen to anyone. And I'm lucky in many respects that I had the grit from a tough upbringing. I had the love and support of my family and friends to help me through this. And I had the resources to fight this. And 99% of the people won't have all three of those. Many won't have any one of those things. And so in many ways, I'm blessed that I had the resources and the support to fight this. And I want to do that. And I want to talk about it now to help make sure that it doesn't happen to anyone else, because it was atrocious. And it's unacceptable for our system of justice to abuse the process this much. I do believe in our justice system. I think it gets it right most of the time, even to this day. But like any large organization, I've run a lot of large organizations, there can be a few bad apples that can, spoil the whole cart, if you will. And in this case, there were a few bad apples who abused the system for their own career gains. And that little map that we saw earlier shows it very clearly that I was the linchpin or the venue anchor for their own careers. And it's despicable what they did to my innocent children, smearing them this way.
But John Wilson, you stood up for yourself, you stood up for your family, you stood up for your kids, but you also stood up for the rest of us, the citizens of this district, of this jurisdiction, to stand for the principle that no, the government should not take your property without notice and an opportunity to be heard. So thank you on behalf of all the folks on whose behalf you stood for that principle, a foundational principle of our country, and we are honored to have filed an amicus brief supporting that principle on your behalf. That's going to wrap up this edition of Sidebar. I want to thank all of you all for tuning in, and I want to thank our panelists, John Wilson, Karen Pickett, and Mike Kendall from the law firm of White & Case for joining us here and sharing their perspectives and their experiences. I want to thank you all, and please be sure to join us next week for the next episode of Sidebar. This is Judge Dan Winslow. Do justice.